to the League of American Orchestras' third online offering related to the Paycheck Protection Program. My name is Heather Noonan, and I'm Vice President for Advocacy in the League's Washington, D.C. office. Before we get started, just a few opening comments. First, we acknowledge that at this time we are all, individually and institutionally, compelled to turn our attention to the critical needs of our communities in the wake of ongoing racial injustice. This League offering is being recorded so that it can be accessible by all when time allows. During our session today, we'll be taking audience questions. To participate, please use the chat function in FeedLoop or in Zoom, and we'll do our best to answer as many questions as possible. A tip for those of you in FeedLoop: please do not navigate away from the broadcast in your browser window, as you'll be kicked off the session if you do. But if that happens, just rejoin the meeting and you'll pick back up with us. I'd also like to take a moment to welcome a couple members of the press who are with us in the audience. We appreciate your attending. And lastly, a reminder that your feedback on these experiences helps to inform future League offerings. Below the session description, you'll find a link to a brief survey where you can share scores with us and comments with us. And this feedback is really valuable to the League as we continue to inform and shape our future content. So I do hope you'll take a moment to complete the survey. So again, we welcome you to today's session on the Paycheck Protection Program's loan forgiveness process. Joining us once again for the third League webinar on this topic is Kyle Miller from the law firm of Pryor Cashman, LLP. And before I hand it over to Kyle, I'd like to thank Orchestras for sending questions in advance of this webinar. We've used these questions to shape the content we'll cover today. We've been receiving questions up to the moment and hope to incorporate as many of those as possible. And of course, we also invite you to share your questions in the course of this session through the chat feature. We do hope to go through the entire presentation and then address the additional questions we're receiving, just to make sure we make our way through the full scope of content in the course of the time available. Additionally, we want to point out what you already know, which is that the landscape of the Paycheck Protection Program policies has changed significantly in just the last few days. Following the passage of the Paycheck Protection Program Flexibility Act this past Wednesday, we've pivoted to incorporate as much of this new information as is possible, but we have to point out that some information is still not available and will require yet another round of new guidance from the federal agencies administering this program. You'll be able to find the most up-to-date information on these changes and also information about how the League is advancing policy efforts through our COVID-19 federal assistance resources, which are always available on the League's website and updated continuously. We'd also like to remind you that the League, in partnership with Pryor Cashman LLP, has available individualized technical assistance on the COVID-19 federal relief opportunities from qualified legal experts from the Pryor Cashman law firm. This is offered at a steeply discounted rate, and we hope that you'll make use of this opportunity. More information on those consultations is available within the League's COVID-19 Federal Assistance Resource page. With that lengthy introduction, and with our deep appreciation for all of the work Kyle has put in the last few days to prepare this latest information, I'll hand it over to Kyle Miller.
Thank you very much, Heather. Really appreciate the opportunity to join you for this, as you mentioned, third seminar on the Paycheck Protection Program. As you mentioned, the original focus was really going to be on the forgiveness guidance that came out from the SBA a couple of weeks ago. But as we were planning and putting together the presentation, the House of Representatives and Senate passed the Paycheck Protection Forgiveness or Flexibility Act, which was just passed by the Senate on Wednesday. And last I checked, we're still expecting the president to sign it any minute or hour now. So we're going to start out talking about the Paycheck Protection Flexibility Act, which I might call the PPFA, kind of wordy. And as you mentioned, we do expect further guidance. For now, when we talk about forgiveness, we're going to assume that all of the SBA's existing forgiveness guidance continues to apply. And when you go to make your application, you should make sure that you've reviewed all of the latest guidance, because we do expect that there will be more. And the PPFA is going to change how the existing forgiveness guidance applies in some ways. And I'm going to talk about those as we go through the presentation. And it's also going to change what our focus is on. So for example, when we're talking about an 8-week covered period, there's more of an emphasis on trying to get some additional days into that covered period, which we'll talk about, whether you can add some days on at the beginning or at the end. That's going to be less of a focus if you have a 24-week covered period. We'll talk all about all of that as we get into it. So the Paycheck Protection Flexibility Act, which is this new legislation that just passed Congress and we're waiting to be signed, makes several changes to the Paycheck Protection Program. So it's a little frustrating that it's constantly changing, but most of these changes are for the benefit of the borrowers. So it's, for the most part, good news. So the first change, it extends the maturity for new paycheck protection loans to 5 years. When I say new loans, I mean loans that are made after the effective date of the PPFA. But it also says that borrowers and lenders may mutually agree to extend their 2-year loan, so any loan that's been made so far is 2 years, to the 5-year term. It is not mandatory on the lenders, so they'll have to agree to that with you if you want to extend. Next, it extends the covered period from 8 weeks to 24 weeks. So the covered period is the period that you have to use your loan proceeds to get forgiveness for your payroll costs and non-payroll costs. With this extension from 8 to 24, borrowers will still have the option to use the earlier 8-week period. Why might a borrower opt to use the 8-week period instead of the 24-week period? Because you'll have to remember that as part of the program, you have to maintain your full-time equivalent employees and not do any salary cuts in excess of 25% throughout the covered period. So if you opt for a longer 24-week period, you'll have to maintain those for a longer period of time. What's unclear here is if you can choose a period between an 8 and 24 weeks. So you would just stop it as soon as you've maxed out your payroll costs and non-payroll costs and use the entire loan proceeds. That would obviously be the most beneficial, but the text of the act seems to suggest it's an all or nothing 8 or 24 weeks. Next, it extends the June 30th safe harbor for rehiring and restoring decreased salaries to December 31st. So if you'll remember, in the program, you have to maintain your full-time equivalent employees and salaries. But if you don't, and you got them back to June 30th, now December 31st, if you got them back to their prior levels by those dates, you would get the benefit of full forgiveness, notwithstanding the earlier reductions. So that extension is helpful. It adds 2 new safe harbors. So the first safe harbor is a safe harbor for organizations that are able to demonstrate that they have an inability to rehire individuals who were employees on February 15th, and an inability to hire similarly qualified employees for unfilled positions. So if you have a reduction in full-time equivalent employees, because you're unable to rehire individuals and you're unable to hire similarly qualified individuals, you're not going to have your loan forgiveness amount reduced. It also adds a safe harbor for organizations that can demonstrate an inability to return to prior levels of business activity due to compliance with governmental regulations or guidance related to sanitation, social distancing, or any other worker or customer safety requirement related to COVID-19. I think this one will be key for orchestras, as you may not be able to reopen for performances at any period during the covered period. It'll be beneficial to not have to maintain your FTEs throughout the covered period. What we don't know is how this will apply if, for example, social distancing requirements are relaxed late in the year, say in November or December, such that you're able to reopen only for a very limited portion of the period between now and December 31st. It makes sense that you would have some partial benefit from this safe harbor, if not the full benefit, but that's TBD. Next, it replaces the requirement that 75% of the forgivable amount be used for payroll costs with a requirement that 60% of the loan amount be used for payroll costs. And it's an important distinction there between 75% of the forgivable amount and 60% of the loan amount. So the way that the PPFA is drafted suggests that if you don't use 60% of the loan amount for payroll costs, the loan would not be eligible for forgiveness at all. Now, a couple members of Congress, Senate leadership has indicated that was not their intent and that they want it to work the same way that the SBA's 75% threshold had worked, which would mean that you only have to have, you can have any amount forgiven, and it's just that that amount has to be comprised of at least 60% payroll costs. It's TBD whether there will be guidance that will make that interpretation the law. If not, there's also a chance that Congress could act again to amend this provision, since right now it does clearly state that you're not eligible if you don't make at least 60% of the loan amount. Next, it replaces the 6-month deferral of payments. So there were no payments originally on these loans for 6 months. It will now be until the lender has decided on your forgiveness application. That application has gone to the SBA, and the SBA has remitted the forgivable amount to the lender. So essentially, the final decision on forgiveness has been made. Will be the earliest date that you would have to make any payments on an unforgivable amount. Lastly, it allows PPP borrowers to take advantage of payroll tax deferrals in the CARES Act. So originally, if you borrowed a PPP loan and it was forgiven, you were not eligible to defer payroll taxes. Now you will. It's just as a quick reminder. It allows you to defer your payroll taxes between March 27th and December 31 of this year, with half being due at the end of 2021 and half being due at the end of 2022. So now moving into the forgiveness calculation. And again, we're going to talk about the forgiveness based on the SBA's existing forgiveness guidance that came out before the PPFA was passed. It's unclear if anything in the PPFA is going to change. Again, a couple of specific things which I will mention. So I like to think of calculating forgiveness as a 3-step process. First, you're going to determine the maximum forgivable amount, which is going to be the sum of your payroll costs and your non-payroll costs during the covered period. Next, you determine whether any reductions apply because you have a reduction in full-time equivalents during the covered period as compared to the reference period, or any reductions in salary in excess of 25% during the covered period. Lastly, you're going to determine if that safe harbor applies because you have rehired employees or restored earlier salary cuts by December 31st. Lastly, just want to mention that if you've taken out an economic injury disaster loan, there was an advance available of up to $10,000. The advance amount will be deducted from your forgiveness. So step 1, determining the maximum amount. So this is largely a refresher from what we already knew about the Paycheck Protection Program. So the maximum forgivable amount is equal to the sum of the following costs incurred and payments made during the covered period. So it's payroll costs, mortgage interest on real or personal property, payments of rent on real or personal property, or utility payments for electricity, gas, water, transportation, telephone, or internet access. And remember that payroll costs must be at least 60% of the loan amount, or possibly the forgiveness amount. That's what we're waiting on some additional guidance or possibly congressional action on. Payroll costs, this is again just a little bit of a refresher. It consists of salary and wages, cash tips, payments for certain types of leave, allowance for separation or dismissal, payment for the provision of group health care benefits and retirement, payment of state and local taxes assessed on compensation of employees that are paid by the employer, and for independent contractors only, their self-employment earnings but a employer is not eligible to include the independent contractors' payments. The cash portion of payroll costs, remember, cannot be more than $100,000 as prorated for the 24 or 8-week covered period. So the covered period for payroll costs, certain borrowers are going to have a choice of what 24 or 8-week period to use. So the regular covered period begins on the day the loan was originated. All borrowers have the option of using that as their covered period. There's also an alternative payroll covered period, which is a 24-week period beginning on the first day of the borrower's first payroll cycle after the loan is originated. That is only available for borrowers with a biweekly or more frequent payroll. Biweekly means every 2 weeks, so 26 pay periods a year. Many employers will use a semi-monthly pay cycle, which is 24. If you use semi-monthly, that would be less frequent, not more frequent. So you would not be eligible to use the alternative payroll covered period. The purpose of the alternative payroll covered period is just to more closely align the covered period with the payroll periods and make it a little bit easier to calculate for certain borrowers. And again, borrowers have the option to use an 8-week covered period as opposed to a 24-week period. Also presumably would apply to the alternative payroll covered period. You can use 8 weeks or 24 weeks. Unclear if you can choose something between 8 and 24 weeks. Payroll costs may be included if they are either paid or incurred, but you see the asterisks there. Payroll costs that are incurred during the covered period but not paid during the covered period are only includable if the employee works during the covered period and the amount is paid in the next regular pay date after the covered period. So you cannot include days that maybe, or items that were incurred in advance, like health insurance benefits that may be paid in advance prior to the covered period, but that apply for a period of the covered period. You can only include a payroll cost that's incurred but not paid if it is paid immediately after the covered period on the next payment date. So some questions on this paid or incurred concept. Has there been more clarification regarding the actual time period of payroll that can be forgiven? I've heard that paid and incurred may be able to be included, which may end up being more than 56 days. So 56 days was 8 weeks. Now we're talking about 24 weeks, but I think the question still applies. So to go through an example, if you have a semi-monthly pay period and your covered period starts April 25th, on your April 30th pay date, if you're paying for April 16th to 30th, you would include that entire pay period, the amounts paid on the 30th, even though the days worked the 16th through the 24th would be prior to the start of the covered period. Then you'll include several pay periods for which the amounts are both incurred for a period during the covered period and are paid during the covered period. Those are obviously includable, though only includable once, not twice. And then at the very end of the covered period, you'll have some days that are in the covered period, but will be paid immediately after the covered period on the next paid date. Those may also be included, but not days after the covered period. So effectively, you would, in this example, have the 56 days if you were using an 8-week covered period, or 24 weeks if you were using a longer covered period, plus an extra 10 or so days at the beginning of the covered period that were included. Next question, we received our funds from the PPP loan on April 22nd. So this covered period starts April 22nd. Our next payday was April 24th. For a pay period of April 3rd to April 17th. Are we allowed to use this payroll payment in our forgiveness application? So this is very similar to the example I just went over. The one difference, and why I wanted to address it separately, is that here the pay date is not the last day of the pay, it's not for the period ending on that day, it's delayed by a week. So on April 24th, you're paying for the 3rd to the 17th. And because of that, you're actually going to have 2 pay periods, your April 24th payroll, and presumably the next payroll is going to be around May 8th. Both of those are going to cover a period that, at least in part, is prior to the start of the covered period. Both of those should be includable because they are paid during the covered period. So your April 24th will be includable in full. Your May 8th will be includable in full. It may seem like this borrower is going to get even more. You know, in the previous example, we had 10 days over the covered period. It might seem that this borrower is going to get even more than that. But you have to keep in mind that at the end of the covered period, they're only going to be able to include the 1 payroll that is paid immediately after the end of the covered period. Their second payroll after that will likely still include some of the days during the covered period, but that would not be eligible for inclusion because it's not the next pay date immediately after the covered period. I know that's a bit technical, so I apologize, but that's kind of how it's written. So I want to make sure I cover it all. One other point on this, it's not clear to what extent you could say repay old wages and include them because they're paid during the covered period. You are eligible to include, and we'll cover this on one of the upcoming slides, bonuses. So it stands to reason that as long as you're not exceeding $100,000 per employee as prorated during the covered period, that you can include additional amounts. But it's a little unclear to what extent you can go back and repay salary to someone that perhaps had been furloughed and then you were brought back during the covered period. So this is what I was just mentioning. Salary, wages, or commissions to furloughed employees may be included. So if an employee is not working, you can still pay them. We always assume that, but it's good to have clarity on that. For employees who are not performing work but are still on the borrower's payroll, payroll costs are incurred based on the schedule established by the borrower, which is typically each day that the employee would have performed work. What about employees who do not have a regular work schedule, like musicians? Well, you know, that each day that the employee would have performed work isn't very helpful in that circumstance. It does still say it's a schedule established by the borrower, which implies that you should have some latitude in establishing your own schedule for when the employees would have worked. I suggest trying to be reasonable, using history as a guide. And that's really all you can do absent further guidance. And then, as I mentioned, hazard pay and bonuses paid to an employee during the covered period may be included, subject to the $100,000 cap as prorated for the covered period. Moving on to non-payroll costs, it's kind of the same rule that applies for payroll costs. So non-payroll costs, which is your mortgage, interest, rent, and utilities, may be included if they're paid during the covered period or if they're incurred during the covered period and paid on or before the next regular billing date, even if that billing date is after the covered period. Note that the alternative payroll covered period for borrowers that are using that does not apply to non-payroll costs. So if you're using the alternative payroll covered period for your payroll costs, you would still use the regular covered period for your non-payroll costs. Sorry, I skipped that slide. Going on to the next one. Question, is it correct that expenses incurred during the eligibility period but paid on or before the next payroll date after the period are allowed, but that expenses incurred during the eligibility period but paid before the loan was received are not allowed? This penalizes those of us who pay rent and healthcare insurance a few days before the due dates, right? So this question touches on healthcare insurance, which would be a payroll cost, and rent, which is a non-payroll cost. But I think you get the same answer. Costs that are paid during the covered period, that are not paid during the covered period, can only be included if they're paid on or before the next scheduled payment date after the covered period. So it appears that something that's paid in advance but covers a portion of the covered period would not be includable. Moving on to step 2 in this forgiveness analysis. So in general, the maximum forgivable amount that you've determined in step 1 will be reduced by a percentage equal to the percent reduction in full-time equivalent employees during the covered period as compared to a reference period. So for example, a borrower has 10 full-time equivalent employees during its reference period. During the covered period, it declines to 8 full-time equivalent employees. Its FTEs have dropped by 20%, so the forgivable amount will be decreased by 20%. The reference period is a period selected by the borrower. Non-seasonal borrowers can pick February 15, 2019 to June 30, 2019, or January 1, 2020 through February 29, 2020. Seasonal borrowers, and there's still no guidance on what constitutes a seasonal borrower, can use either of the options that non-seasonal borrowers can select. They also have the option of using any consecutive 12-week period between May 1, 2019 and September 15, 2019. So they're letting you pick the period based on what your seasonality is. Again, the borrower can pick whichever of these is most favorable for both non-seasonal and seasonal. So for determining FTEs, they've adopted a simple 40-hour work week standard. So you calculate the average number of hours each employee works per week during the covered period or the reference period. You divide that by 40, and you're going to get a number that's going to be around 1 for a full-time employee or something less than 1 for a non-full-time employee. You're going to cap that number at 1, so nobody can be more than a full-time employee. So for example, if you have an employee who's working on average 50 hours per week, you're going to divide 50 by 40, you'd get 1.25, but the number is capped at 1.0, so 1.0 is the number for that employee. If you had an employee who works 30 hours per week, 30 divided by 40 is 0.75, and an employee who works 10 hours per week, 10 divided by 40 is 0.25 FTEs. So that's option 1 for determining FTEs. There's also an alternate method, which is option 2, which essentially allows you to simplify part-time employees to all be 0.5 FTEs. To go through the same examples, the 50-hour-a-week employee is still going to be 1.0. Anyone in excess of 40 will be 1.0. But your 30-hour employee, who would otherwise be a 0.5 FTE, is going to be a 0.5. And your 10-hour employee, who would be a 0.25, is also going to be a 0.5. So all your part-time employees can be 0.5. They're trying to make it a little bit simpler for borrowers that don't have detailed hours worked records. However, you must be consistent. You have to apply the same formula during your covered period or alternative payroll covered period and your reference period. You can't pick and choose whichever is more favorable. So now that you've figured out your FTEs for each individual employee, how do you calculate the reduction amount? So you determine the FTE amount for all employees during the covered period or alternative payroll covered period and the reference period. You add those all up. You divide the total FTEs during the covered period or alternative covered period by the total FTEs during the reference period to get a reduction factor. If the amount is 1 or greater, no reduction is required. If the amount is less than 1, the forgivable amount is going to be determined by multiplying the reduction factor by the maximum forgivable amount. So a question on this, seems like we should be able to take the total hours of an employee for the look-back period and divide by full-time hours for the look-back period. But I heard in another seminar that we need to calculate it for each individual week and then average. This will take a lot more time and seems like it would come out the same. So for doing this analysis, you're looking at average hours per week during the covered period. So you would just divide the total hours worked during the covered period by 24 weeks or 8 weeks. You don't need to do a FTE calculation on a weekly basis. So I think there was a little misunderstanding on how you have to do this here. Still in step 2, you're also going to have to reduce the maximum forgiveness amount based on reductions in salary. So in general, there's going to be a reduction for reductions in salary or wages of certain employees that are in excess of 25%. Which employees does this apply to? Any employee that was not paid $100,000 or more in any period in 2019, and any new employee. So if you have a new employee who has started, their first day of work was in 2020, and they're making $200,000 a year, the 25% reduction limit will still apply to them. However, if you have an employee who started prior to 2020 and they made $100,000 annual rate based on just one single paycheck in 2019, that employee would not be subject to the 25% cap. So how does this work? You compare the average weekly compensation during a reference period, which for this is just January 1, 2020 to March 31, 2020, to the average weekly compensation during the covered period or alternative payroll covered period. If the amount during the covered period or the alternative payroll covered period is more than 25% lower than during the reference period, the forgivable amount is reduced. One thing that they've put in here was that the average compensation during the reference period that you're comparing to is the base compensation. And there's no definition of what base compensation is, but it stands to reason that if somebody was getting paid for overtime during the reference period and you've decreased beyond 25% based only on their overtime, that you shouldn't be penalized for that. So I expect that base compensation includes or excludes things like overtime, perhaps bonuses as well, because I think it would be unfair to penalize borrowers that are not paying overtime right now since employees are not working right now. This calculation is going to be performed on each individual employee, not on an aggregate basis. And then you're going to reduce the forgivable amount on a dollar-for-dollar basis for each employee based on each dollar in excess of 25%. So it's not that once salary has been increased by an excess of 25% that you decrease the forgivable amount based on the entire. It's only by each dollar in excess of 25%. The interplay of FTE reductions and salary reductions. So a reduction in salary will not also result in a reduction of forgiveness to the extent that the reduction in salary resulted from the reduction in full-time equivalent employees. So for example, an employee was previously working 40 hours per week, so they were 1.0 FTE. They had their hours cut to 20 hours per week, 0.5 FTEs, and their weekly salary went down from $1,000 to $500. In this example, there's a reduction in forgiveness as a result of the decrease in FTEs, assuming at least that there wasn't an increase in someone else's FTE hours. But there's not going to be an additional reduction based on the change in salary because the change in salary is attributable to the change in hours. But in this example, if the hours were cut from 40 hours a week to 20 hours a week, and the salary was reduced from 1,000 to 250 per week, the reduction in salary is not entirely attributable to the reduction in FTE hours, so you would have to do both reductions. A couple of questions. How to figure the average hourly wage for per service orchestra members when they are paid different rates for rehearsals and performances and also can be paid at scale or principal. Seems like we can get penalized if someone filled in for a principal during the look back period, but scale during the covered period because their average pay rate went down through no fault of the organization. This is a really interesting question. So I have a couple of thoughts on it. One is that you have the option of just being consistent with your reference period and paying everyone essentially the same rates. Obviously, that may not be desirable where you have a substitute musician who is filling in and they had no expectation of being paid at the principal rate during any covered period. So you may not want to do that. What's your other option? I suppose you can rely on the language I mentioned about looking at base salary during the reference period and suggest that that person's base salary was based on their scale or substitute musician rate, not based on what they would have actually been paid as principal. I don't know how the SBA will view this, how much opportunity you'll have to explain it, or to what extent base salary applies to things where employees have two different rates as opposed to just a kind of overtime or bonus situation. So there really is no guidance on this. You may try it, absent guidance to the contrary. Otherwise, if you don't want to do option one, which is to just be consistent with the reference period, and the second alternative option doesn't apply because of SBA guidance, you'll just have to suffer the reduction in forgiveness because the person will be paid a lower rate during the covered period than the reference period. Next question, we've paid our musicians for canceled services with PPP funds, paying them within the 8-week period after the loan was received. I've heard that we might also need to pay musicians that may not have lost services, but did work in the previous quarter, that names would be compared as part of this particular criteria. In other words, if Joe Smith worked in February, the first quarter, but not get paid for lost services in March, we still need to pay him at least 75% of what he earned in that first quarter. Is this true? You need to keep in mind that there is no reduction for salary to the extent that the reduction in salary was totally attributable to a reduction in FTEs. So if you had employees who, let's say, were working 40 hours a week and they were 1.0 FTE during the reference period, and they went down to 0.0 FTEs during the covered period, and you did not pay them, you would have a reduction based on the reduction in FTEs, not a separate reduction based on the reduction in salary. If you had other people who are working, you were just paying different employees during the covered period, then your aggregate loss in FTEs might be zero. You might have as many musicians you're paying during the covered period as during the reference period, even though certain musicians are not still being paid. If your FTEs are consistent, then it shouldn't matter that certain individuals are not being paid because there's no duplicate reduction for salary if your FTEs are constant. Now we move on to safe harbor, which is this restoration of full-time equivalents or salaries by December 31st. So if employee salaries and wages were reduced between Feb 15 and April 26, such that a reduction in forgiveness would be required, no reduction will apply if the reduction is eliminated by December 31st, 2020. For salary reductions, it's a little unclear if you have to restore back to 100% or just to within 25%. I think I originally had thought it would just be to within 25% of the original salary levels. I think the latest guidance is a little bit more unclear on that point. Similarly, if a borrower reduced full-time equivalents between the period or during the period between Feb 15 and April 26, such that a reduction in forgiveness would be required, no reduction will be required if the reduction in FTEs is eliminated by December 31st or earlier. That or earlier is a little interesting because it doesn't say how long you have to maintain it for. You would think you have to maintain it through December 31st, but it's a little unclear if you just have to maintain it for any single pay period after your covered period and before December 31st, or how that will be implemented in practice. Questions on this? We are likely to have the same headcount at the end of our covered period as at the beginning. We are also likely to furlough and lay off after the period. Since we have the same count at the end of the loan period, does it matter what our headcount is on December 31st? Remember for this, you're not comparing headcount at the end of the covered period as at the beginning of the covered period. You're comparing your headcount throughout the covered period, your average headcount, as compared to the reference period. If your headcount during the covered period and the reference period are the same, then yes, you could do layoffs after the covered period and not worry about December 31st, because December 31st is only a safe harbor for borrowers that did have a decrease that are rehiring workers. So the December 31st deadline would be irrelevant in this example. So the Paycheck Protection Flexibility Act added a couple of safe harbors, which we already discussed: the inability to rehire individuals who are employees on February 15th, and an inability to hire similarly qualified employees, and an inability to return to prior levels of business activities due to compliance with governmental requirements. I'm not going to talk about those again since we covered them at the beginning. There were a couple of safe harbors that were a part of SBA guidance. It's a little unclear how they still apply after the PPFA. So the first safe harbor was if you've made a good faith offer to rehire an employee, the borrower may calculate forgiveness excluding any reduction in FTE headcount attributable to that employee. The same applies to a reduction in hours. So there were a number of requirements that went with this. Borrower made a good faith written offer to rehire for the same salary or wages. Offer was rejected by the employee. The borrower maintains records documenting the offer and rejection, and the borrower informs the state unemployment insurance office of the rejected offer. I say it's unclear if this still applies because the PPFA has the safe harbor that applies if there's an inability to rehire workers and an inability to hire similarly qualified workers. So this safe harbor that the SBA had put in didn't have that additional element of inability to hire other similarly qualified workers. My expectation is likely that the new safe harbor under the PPFA would essentially trump this safe harbor that the SBA had created. There's also a safe harbor for employees who are fired for cause. And this essentially said if an employee was fired for cause, voluntarily resigned, or voluntarily requested a reduction in hours, the borrower could count the employees at the same FTE level as before such event occurred for calculating the FTE employee reduction. So for example, if an employee was working 40 hours per week during the reference period, at the beginning of the covered period, their hours were reduced to 20 hours per week. 4 weeks into the covered period, the employee is fired for cause. You're going to be able to treat that employee as 0.5 FTEs for the entire covered period, even though they were terminated part of the way through the covered period. Again, I think it's a little unclear if this will continue to apply or if you will have the added requirement that you're unable to hire a similarly qualified employee, which is what was possibly added by the PPFA. Lastly, your next steps with this. The SBA has also published its form of forgiveness application, which details the documentation that will need to be included when you apply. I expect that the application form will change a bit to reflect the longer covered period and the other changes implemented by the PPFA, but I suggest downloading it, reviewing it. You may wait until the revised form is available, but look at the documentation that you'll need to include when you apply, and make sure that you'll be able to complete the form in advance when the covered period is coming to an end. A quick note on what happens after you apply. The lender has 60 days after the application to make a decision on your forgiveness. And then after they make their decision, they submit it to the SBA, and the SBA has an additional 90 days during which it can review it and ultimately make the amount of the forgivable funds available to the lender. So it's potentially up to 5 months after you submit your application before you have a final decision. But the good news is because of the PPFA, your repayment does not start after 6 months. you have that entire period of while you're waiting as an additional deferral, payment deferral. So that's my presentation for today. I think we have some time for questions.
Thank you very much, Kyle. Yes, I'm so glad we have time for questions because there are many of them. I wanted to begin with the new safe harbor provided in the Flexibility Act. And someone has asked a question that I think a number of us on the policy side have been considering as well, which is, when it comes to the safe harbor, does it apply to both the reduction in wages and FTE count? The actual language of the Act only specifies FTE count. Do we know whether it applies to both, or how we might hear consideration about that from the agencies moving forward?
That's a great question. It does only say that it applies to FTEs. I would expect that we'll get guidance that it also applies to salaries, to the extent that an employee has their hours reduced because there's nothing for them to do and it falls within the safe harbor. It wouldn't make sense that the safe harbor applies to the reduction in FTEs, but not to the reduction in salary that results from the reduction in FTEs. So I would think that they'll have similar guidance on these provisions as to what they've already put in place for the general rule that salary reductions do not count to the extent they're attributable to the reduction in FTEs.
Thank you. There are also some questions regarding the timing of seeking loan forgiveness, given the new dynamics of a option of 8 or 24 weeks, and then also considering this safe harbor timeframe of through December 31. So I'll try to frame these up in ways that maybe can be addressed as a bunch, Kyle. But I think a preliminary question is, if a borrower elects for the 8-week period, what does the timing look like for applying for forgiveness? I know a number of orchestras are considering that they, at the conclusion of that period, may need to diminish payroll.
Right. I haven't seen anything specific, but I expect that you'll be able to apply pretty much right away. We may be stuck waiting at least for a couple weeks to get a updated application available. But I think if you're applying using the 8-week covered period, you would be able to apply pretty quickly thereafter. The one caveat being that if you're relying on the December 31st safe harbor, you presumably won't be able to apply until after December 31st because you won't be able to demonstrate that you've maintained your payroll and your FTEs, or that you've restored your payroll and FTEs until you actually have done that. So that's a little bit of a question mark, and I think we need a little bit more guidance on.
Yeah, thank you. I think that second part is probably one of the most important considerations that everyone has in mind right now. It's an interest to get the forgiveness process application moving as quickly as possible, but it seems a high percentage of orchestra stakeholders would want to make use of that safe harbor. So as we get more guidance, we'll be sure to provide information just as soon as possible. There's another question from those who won't exhaust their PPP resources until beyond the 8-week period. And so ideally, they would be able to apply as much of those costs as possible to loan forgiveness. Would they need to wait until the end of the 24-week period to apply for loan forgiveness? And if they exhaust their funds somewhere in between, how do you think that plays out in terms of a strategy for pursuing loan forgiveness?
Yeah, it's an interesting question, and that's where it'll be key to see if they adopt a rule that permits borrowers to adopt a covered period between 8 and 24 weeks. Because if you're stuck using 24 weeks as your number, you're not going to be able to apply until the end because you're going to need to submit documentation showing that you've maintained your FTEs and your salaries for the entire 24-week covered period. So it's going to be, I think it'll be key to see if that's adopted. because it's really going to be a challenging decision for orchestras and other organizations to make on whether they do use the 24-week period if it means that they need to maintain their payroll for the entire longer period.
Thank you. We have a number of questions that have come in that are related to the covered period's allowable costs. And so we have a few examples to share with you, Kyle, and see if there is yet clarity on some of these pieces. I just remind everyone that we do have the 2 prior webinars that go over some of the basic information around eligible costs, but also in the interim, we've had additional guidance by way of interim rules from the agencies. And then we also have a ever-growing list of questions and answers that the agencies have issued that are setting new policy along the way. So Kyle, some of this might be a review, but some of these may be treated somewhat differently since our last webinar. So regarding coverable payroll costs, payroll fees?
Payroll fees, I haven't seen any specific guidance on whether fees are includable or not.
Okay. For those who are providing COBRA assistance for furloughed workers, is that an allowable payroll cost?
I would think it would be based on the allowance of payment for the provision of employee benefits consisting of group health care coverage, including insurance premiums. I would think that would fall within insurance premiums.
The next question is around retirement benefits. You confirmed that retirement benefits are covered. Some organizations are currently paying catch-up retirement benefits. So their actual retirement benefit payments might exceed the usual benefits per payroll period. Would those catch-up payments be eligible as a cost, or would they need to average it back out?
I don't know if there's a clear answer on that. I think that the fact that you can include bonus and hazard pay suggests that amounts in excess of ordinary amounts attributable to the covered period could be included as long as you're staying below the $100,000 cap per employee as prorated for the covered period. So it may be worth the try. I haven't seen anything specifically indicating that they wouldn't be includable.
All right. We also have a question around workers' compensation that is typically paid on an annualized basis. And if they're incurring workers' comp expenses, would that be an allowable per pay period cost?
I haven't seen a specific answer on it, and I'd want to get more color or more clarity from the SBA before I gave a definitive answer on that one.
Okay, thank you. Shifting over to the FTE standards, suffice to say, I think very many of us will want to rewatch this webinar several times over to understand the nuance to all of the detailed answers you've given, Kyle, to the specific questions that apply to orchestras. So first off, I just want to remind everyone we will be making a recording available as well as the slides presented here so that we can all absorb this information at our own pace. In the meantime, in the relatively recent round of regulations from last week, Treasury did confirm the 40-hour basis for the FTE formula, as you mentioned, Kyle. I just wanted to back up and I don't know if it's possible to scroll back to that set of slides, but just to back up to give folks one more glance at that and to confirm it. Several have weighed in to say they typically have a 37.5-hour work week. Does that still mean they use the 40?
That's right. So they'll have to use the 40-hour work week standard for the purposes of calculating this for purposes of loan forgiveness reduction. They don't let you use whatever formula you may generally use for accounting purposes. You're obligated to use the 40-hour work week standard. on one of our prior webinars, we had speculated that there might be more complexity to this, that there are other formulas that the various government agencies use for calculating FTEs that go on for pages and pages and, for example, exclude workers who only work a given number of days. None of that is going to be relevant here. They're going with, I know it didn't seem it as I was describing it, but a relatively simple standard compared to what the government uses for other purposes. So it is essentially just the 40-hour work week standard.
And another question, this one kind of dials back to a very basic one, but we have had a few people asking it. In our initial webinar, we informed potential borrowers that as an organizational applicant for PPP funds, their eligible payroll costs are limited to your W-2 workers. And there are orchestras that exclusively engage their workforce through a 1099 relationship. Those are not eligible. That's not an eligible use of PPP funds, correct?
That's right. They're not considered payroll costs for the organization. The rationale is that independent contractors are eligible to apply on their own, and they didn't want them essentially being double counted, being the workers applying for themselves, and then the organizations that pay them also applying. So the organization is not eligible to include those in its payroll costs, either for calculating the loan amount or for calculating forgiveness.
Perhaps on a related question, we've had one audience member ask to review the terms for interest accrual on the unforgiven portion of a loan.
It's 2%, isn't it? Sorry, I'm going back and trying to jog my memory. I've been so focused on forgiveness. I think it's 2%.
Yeah, I'm grasping for it as well. I think so much of our attention has been on the forgiveness piece, but we can return to this and make sure we'll confirm the amount. We also have some questions, if you're able to scroll up to the preceding slide, that is regarding choosing the reference period. I know this question has been asked to you several times, Kyle, and we keep coming up with the same answer, which is no fault of yours, but lots of questions about, am I a seasonal employer? And we just simply don't have guidance on any definition. It appears that one could self-select as a seasonal employer, as well as the seasonal employment period among the options offered under guidance. Do you have anything further to add to that? And is that correct?
No, I think you said it exactly. There has been no guidance on what a seasonal borrower is. It certainly seems like the kind of thing that the SBA has had ample opportunity to issue guidance on and would have issued guidance by now if it had intended to do so. So it does seem like it's a question of self-selection. I suppose there's always the risk that your lender will take a look and say, actually, you're not a seasonal borrower, that this was intended for something really seasonal like agriculture. And it may be factor specific for orchestras. I know that some orchestras have a almost full year season and other orchestras have a half year or maybe even a quarter year season. Certainly those quarter and half years look very much like seasonal businesses, whereas a 48-week season looks a little bit less seasonal. That said, I don't know that there's anything that precludes a 48-week season from orchestra from opting in, because it is at least in part seasonal, and you can certainly make the case that it's seasonal. So it may be that there's some standard somewhere in between where there's a cutoff, but nothing that's been spelled out by the SBA to date.
Actually, I guess I could say many orchestras, in the spirit of the intention of the Paycheck Protection Program, have used resources to bring workers on payroll and to maximize their eligible loan amount with the anticipation of full forgiveness, bringing workers back onto the payroll who may or may not have had work presented to them, certainly under the current circumstances that could be fully executed, but may or may not have had planned engagements prior to the public health emergency declaration. We've several times, I think, confirmed that the fact that work is not done during this period does not impact the eligible payroll costs. But would you mind speaking to that just once more, Kyle?
Yeah, I think we always speculated that that would be the case. They've since come out in the forgiveness guidance and said very specifically that furloughed workers who are paid are eligible to have those payments included in payroll costs. So I think at this point, it's very clear that if an employee was not performing work, they are includable. I mentioned a little bit that you're supposed to do that incurrence test based on when they would have been doing work, which may be a question for a worker who doesn't have a normal schedule, like a musician. I think the date of incurrence is going to be a little bit less important if you use the 24-week period. If you're still using that 8-week period, that paid and incurred may be a little bit more important because you may be trying to get in those extra days at the beginning of the covered period or just before the covered period, so that incurrence test may matter. And that's where I encourage orchestras to try to use a schedule that's reasonable to the extent that they don't have an actual schedule that they can use because it's just, you know, the workers were never scheduled or whatever other reason, they just don't have a schedule they can use based on what the prior expectation was. Do something that's based on historical precedent or is otherwise just a reasonable expectation of when musicians would have been working for that incurrence date test.
Okay. Thank you. So I think this is another topic where we also want to focus, Kyle, in the last few remaining minutes, which is I'm seeing a number of questions about how orchestras should approach calculations for their forgiveness applications compared to the approach they've taken in their original loan application. So this applies to maximum loan amounts calculated, I think, originally based on taking an annual approach versus a seasonal approach. Also just, I think, a lot of general questions about how to align their loan forgiveness application, given that the guidance has shifted from what they knew based on their application to what is known now. What are some things you can say about considerations to take into account, given how much change is happening in the policy?
Sure. So I would say in general, your decisions for forgiveness, you should try to be consistent with the decisions you made in calculating your payroll costs at the time you applied. To the extent that guidance has changed, you should absolutely apply based on the latest guidance, and that applies to the guidance that's been issued to date, and also that the guidance may be issued between now and when your application is made. I don't think you will be penalized if you are calculating something differently in your forgiveness application as you did during your initial application as a result of a change in guidance. The SBA pretty clearly said that you were eligible to apply based on the guidance that was in effect at the time you applied, but that doesn't mean that you would get to use the same assumptions indefinitely to the extent there's now contrary guidance.
All right. Thank you. I think, again, so much of this is going to be case by case specific, given what point in time one applied for their PPP loan. And we're also aware that the application process is still open, correct? So there may be some that are approaching this topic for the first time now with the extended period in mind.
That's right. There are still unallocated funds available for the program. They've said that applications are only available until June 30th. I think originally we thought that the effect of the PPFA was to extend the application deadline to December 31st. Seems that's no longer the case. So if you are still in a situation where you're looking to apply, you have about 4 weeks left to apply. Although I think it's possible that the funds will get used up now that there's a little bit more liberal rules for when you can use the proceeds. So if you're still waiting to apply, I think now is a great time.
And I guess to that point too, for those asking themselves what happens, what's available after I've exhausted my chance to use the PPP process, there are ongoing policy conversations on the Hill about what comes next, what major forms of COVID-19 relief will be available. There hasn't been a big movement of interest to substantially recapitalize PPP to give people another bite at the apple, although certainly advocates are asking for that as an option. And in terms of timing, when will we know more, about what might come next? Is that Congress is intending to be working on a COVID 4.0 package of new relief, but the full shape of that proposal certainly won't be available until the end of this month, likely early July. So it's frustrating because we don't have insight into what might come next after this just yet. But it's also an opportunity for us to weigh in this policymaking process and explain where the unmet need is. So just as we continue to think about bigger next steps, that's one piece I think we can all remain focused on. Kyle, I'm sure you know exactly at what point Treasury and SBA will issue new guidelines on the flexibility provisions. Do you have any insight on obviously, the league will be making orchestras aware as soon as we see any more information available. But do you have any further insight on where should folks be just keeping their attention as we wait for more information?
I think just reviewing everything that's out there to date, reviewing the application, and trying to figure out how you're going to apply, whether it makes sense for you to use the 8-week covered period or the 24-week covered period. But really, we are in a bit of a wait and see for now. I don't want folks to focus too much on what's out there today when it may very well be trumped by the next set of guidance. But I do think on some level, you're a little bit stuck doing that because it's so important to stay up to date. The guidance is constantly changing. But I do think that those forgiveness rules that were issued about 2 weeks ago now are more or less going to stay effective. It'll probably mostly be a change of 8 to 24 weeks if you're opting for 24 weeks. But you just keep in the back of your mind that everything is subject to change now that the Paycheck Protection and Flexibility Act has been passed.
And I know that a number of borrowers are consulting with their lender through the forgiveness process. How much could they rely on what their lenders know at this moment or as things move forward in time?
I think it's great to talk to your lender. It's probably the single most useful thing you can do. It's entirely possible that the lenders are having conversations directly with the SBA and getting a little bit more guidance on what is and isn't permissible than maybe the general public is aware of. But you also need to do your own analysis, make sure you're comfortable applying and that you've reviewed the guidance, reviewed the application, reviewed everything that's out there. Because at the end of the day, the SBA does have the ability to overrule decisions that the lenders make on the forgiveness application. So your lender could very well be wrong and the SBA could come to a contrary decision.
That's very helpful. Also, I know there are several questions that have come in through the chat feature that we've not had an opportunity to address, but I want to thank you all for bringing them to us because these questions will inform the guidance and resources that we continue to make available through the League's federal assistance page. Also, I'll just remind you that there was a survey form that we included in the invitation to this webinar, the initial promotion of this webinar. that is a way for you to continue to pose questions to us. Again, while we might not be able to address all of them in real time, it's really helpful to see where the information gap is so that we can develop more resources to assist you. And we've already received reassurance from Kyle just before this began that he is standing by to help us with another learning event of this kind just as soon as more complete guidance is available on the flexibility portion of the loan forgiveness process. So please do stand by and stay tuned for another learning event. We will be making this recording available. We'll also make sure that we post on the League's website the slides used here, which I think can be one of the most helpful resources to review. And then also, we just wanted to thank Kyle very much for leading this conversation today. I know it's been 24/7 effort to unpack all this new information and frame it in a way that's so specific to orchestras. So thank you for doing that. Also just want to remind you to please take a look at the survey that is linked in the webinar description for today's session. And just another reminder that what you inform us really does help what we offer next. So please do take a minute to also review your constituency meetings that are in the schedule section of FeedLoop. We're continuing to address content through our conference format. We want to make sure that you don't miss a single bit of it. And also, we wanted to remind you that in just short of an hour, we'll be holding our next session on aligning strategic facility initiatives with the COVID-19 response in mind. And that's something you'll want to be sure to be a part of. So with that, thank you so much for your participation today, and please stay tuned for more information to come.